I'd like to bring in the Southern Coalition of Southern Coalition of Social Justice, and they're going to talk about the intersection of justice and policing. They're going to talk about the legal effects of this bill, how it will impact voters. And our two guests today are Caitlin Kaiser. She serves as the Voting Rights Legal Fellow at the Southern Coalition for Social Justice with their Voting Rights Program, and she joined the SCSJ in 2020. She graduated with honors from North Carolina Central University School of Law, and she is also an award winner. She won the Floyd B. McKissick Award for Leadership and Scholarship and the Pro Bono Service Impact Award. She's going to also be joined by Amy Durant, who serves as senior counsel with SCSJ with their system reform team. And her practice focuses on litigation and community engagement to promote and protect civil rights. And so for the next half hour, you're going to hear from Amy and from Caitlin. I'm just pleased to be able to toss this portion of the program over to you to really hammer, to really talk about the legal ramifications of this bill and just how dangerous it is. And we thank you for being a part of this collective action today and taking part in our virtual summit. Welcome.
Thank you for that introduction. My name is Amy Durant. I'm the senior attorney here with the Justice System Reform team. I'm going to share my screen. We've got a little presentation for y'all today that's going to go along with what we have to say. Okay. So as we mentioned, we're here with the Southern Coalition for Social Justice. Our mission statement is here on the screen. I'm not going to read it out loud for y'all. I think we've got a lot to get through and I'm going to try to be as quick as possible, but I'm going to start our discussion by walking through House Bill 805, breaking down the specific proposed changes and touching on why they are so problematic. Caitlin is then going to take over. She's going to discuss how this proposed bill could affect your voting rights and why that's also so important in this overall conversation about free speech. If you have any questions, please feel free to drop them in the chat. We're also going to try our best to reserve some time at the end for questions. So this is House Bill 805 in all its glory. This is the first page of House Bill 805, I should say. And when reviewing a proposed bill, it can be a little confusing. So the first thing that I wanted to do is walk you through this and explain exactly how to read this, just in case you've never looked at a proposed bill before. So you're going to see language in here that has been struck through. If you look at the middle of the page here, next to C1, you're going to see the first example of that. And that's language that's currently in the statute that's proposed to be removed. There's also language in here that's underlined, which you'll see right underneath that. And that's going to be language that is proposed to be added to the current state or the current statute. So when you read this language together without the stricken language, that's what is proposed to be included in the new statute if this bill is passed. So on HB 805, you see it says section 1 in the middle here. Next to that, it says GS 142882. That's the general statute that's proposed to be changed in this first section of the bill. And that's the statute that we have on rioting and inciting a riot. Down at section or paragraph C1, that's the first paragraph where there's a proposed change that I just pointed you to with the language that's been struck through and the underlined language to be added. So in reading this, the new language for paragraph C would be any person who willfully engages in a riot is guilty of a class H felony if the person possesses any dangerous weapon or substance. And I should say, I know our previous presenters have talked about this, but in case you weren't here for that, section or paragraph A of section 1 defines a riot, and there's no proposed changes to that, but I think it's important that we do look at it because that language is already problematic, and that's part of why all of these other proposed changes in House Bill 805 are so problematic. So in North Carolina, the definition of a riot is a public disturbance involving an assemblage of 3 or more persons, which by disorderly and violent conduct or the imminent threat of disorderly and violent conduct results in injury or damage to persons or property, or creates a clear and present danger of injury or damage to persons or property. And the imminent threat and the clear and present danger language is very important here, excuse me, because it gives broad discretion to prosecutors about what can be considered a quote riot. So it means that there doesn't have to actually be disorderly and violent conduct or injury or damage to persons or property for it to be considered a riot. So throughout this discussion, I'm going to use the word riot because that's what's used in the law, but please consider it with air quotes every time, because what's considered a quote riot to some is not what we always think of as an actual riot. This means that a peaceful protest, or like Mimi was just talking about, if you are just on the sidewalk with some of your friends shooting a TikTok video, that could be considered a riot under our current definition. And especially as it relates to a peaceful protest, this is problematic because that's not only legal in our society, but it's a cornerstone of our democracy. It is so important that we're able to hold these peaceful protests, and this law is trying to prevent us from doing that. So now we're going to go down to paragraph C1 of this bill. And this proposed change basically takes the language that was stricken through in C1 above, but makes it a class felony if there's property damage in excess of $1,500 or there's serious bodily injury that occurs during a quote riot or as a result of a riot. Now, for those of you who don't know, felonies are lettered in order of seriousness. So a Class A felony is going to have the highest potential sentence because it's considered the most serious. Then a Class B felony has the second highest potential sentence, so on and so forth. So when you see these changes in the classes of felony, when you're going in order, the closest you are to A, the higher the potential sentence is going to be. Under C1, it's also important to note that you don't have to actually be the person causing the property damage or the bodily injury to be charged with this crime. The statute merely requires that you willfully engage in the riot and that as a result of the riot, there is property damage or serious bodily injury, and then you can be charged with a Class F felony. C2 right underneath is a completely new provision in the statute that would make it a Class E felony if during the course of a riot there is a death that occurs. Again, you don't need to cause the death or frankly even know that there was a death to be charged with this crime. If you attend a protest that's characterized as a riot and someone dies during that protest, you could potentially serve up to 63 months in prison depending on your criminal history. Now you might be wondering, what if a police officer kills someone during a protest? Under this statute, you could still be on the hook if you are attending that protest. What if someone dies of heat stroke or a heart attack during a protest? Again, under the statute, the way it's worded, it could still be characterized as a quote result of the riot. And if you're attending the riot, you could be on the hook. Now, this language is so broad that it's going to cover a lot of situations, and that's part of what makes this section really problematic. And we're going to discuss that a little more later as well, how the overreaching language in here is part of the big problem with these proposed changes. Paragraphs D and E towards the bottom of the page increase the charges for inciting or urging a riot. Paragraph E1 is another new paragraph, and it's related to C2. So if you willfully incite or urge a riot and a death results, that's a Class D felony now. Going to the next page, paragraph F at the top is another new one. This paragraph actually creates a civil remedy for people whose person or property is damaged in the course of or as a result of a riot. And it says that any person whose person or property is injured by reason of a violation of this section may sue for and recover from the violator 3 times the actual damages sustained, as well as court costs and attorney's fees. This paragraph is so broad and so vague that it seemingly would allow someone whose property was damaged during a protest to sue anyone involved in that protest, not just the person who caused the damage. Would it allow someone whose property is damaged to sue everyone involved in the protest? I don't know. That's a good question. It says the violator, which might imply one person, but since it isn't limited to the person who causes the damage, we just don't know. It's also important to note that there's already a civil remedy for someone whose person or property is damaged. House Bill 805 increases the remedy threefold for those individuals and allows court costs and attorney's fees, in addition to broadening the scope of who can be sued for such an action. So again, if you're at a protest and there's property damage, even if you didn't cause that property damage, even if you didn't know that there was property damage, you could be sued in civil court by the person whose property was damaged. Now we look at section 2 near the top of the page. Right next to it, it says GS 14288.6. And it adds a new section to that statute. So to see how this fits in, you'd have to turn to that specific statute, which is about looting and trespass during an emergency. And so here in very large letters is that statute for you. So reading them together, any person whose person or property is injured by reason of either looting or trespass during an emergency is able to sue the violator for 3 times the actual damages, as well as court costs and attorney's fees. So again, we're seeing an additional civil claim added where a remedy already exists. And again, we have the vague language of the quote violator, which means that you don't have to be the person causing the damage to be sued. So this is very similar to the statute that we just looked at. Section 3 underneath amends General Statute 142889, which is relating to assault on emergency personnel. And the important thing to note about this change is that it removes the requirement that the assault causes physical injury to the emergency personnel, and it also increases the charge. As the law currently stands, any person who commits an assault that causes physical injury to emergency personnel is guilty of a Class I felony. Under the new statute, any person who commits an assault on emergency personnel, regardless of whether there's injury or not, is guilty of a Class H felony. Now, you might be wondering what is considered an assault? And that's a great question because it's not defined in our statutes at all. So we have to look at what is called common law, which basically means case law. And in North Carolina, there are actually several different definitions of what an assault is. And so I picked the broadest definition I could find, which is the unlawful touching or application of force to the body of another person. And so under this definition, basically, if you unlawfully touch any emergency personnel during a protest, then you could be guilty of a Class H felony. Now, some of the definitions in North Carolina case law add additional requirements, such as, attempted violence, or there's more of an intent requirement, but that's not always the case. Now, finally, we get to Section 4 of House Bill 805, which creates an entirely new standard for bail and pretrial release for people charged with any of the crimes that we've just discussed above. Under this new standard, only a judge can determine pretrial release for these defendants, and judges do not work around the clock. Normally, a magistrate can determine pretrial release, and magistrates do work around the clock. This means that if you're charged with a crime relating to rioting or looting, you're going to sit in jail until a judge is available to set your conditions of pretrial release. And that basically means just setting your bail amount. Now, if you look at paragraph B all the way at the bottom here, it says that if a judge has not acted within 48 hours of arrest, the magistrate can then step in. So this supposedly limits the amount of time a defendant can sit in jail for up to 48 hours. And now if you're being arrested at a protest, it's very likely that it's going to be in the afternoon or at night, could even be on a Friday, could be over the weekend. That means you could sit in jail for up to 48 hours until either a judge is available to set your pretrial release, or a judge isn't available and a magistrate can step in. But if you look at section A1 above that, A1 allows a judge to retain a defendant in custody for a, quote, reasonable period of time to determine the conditions of pretrial release, which means that a defendant could sit in jail for longer than 48 hours as long as the judge is thinking about what to do. Now, folks, that's a long time to sit in jail when you have only been accused of a crime. It's just unreasonable, and it's another example of how lawmakers are trying to make this as burdensome as possible to deter people from protesting. This section has a couple of other fun tidbits, but I'm not going to go into those because I think I'm running out of time. So as we've just gone over, this proposal makes the laws relating to rioting and looting more broad, more vague, and more harsh. When we're talking about laws relating to our free speech, this is incredibly problematic. Individuals have a constitutional right to peacefully protest in this country. The government cannot restrict the content of our speech, with a few limited exceptions. And one of those exceptions is inciting a riot, which we just discussed. But there are a few limited exceptions to this. This means that the government cannot outlaw Black Lives Matter protests altogether. That would be an unconstitutional content restriction. And while this bill does not technically restrict the content of protests, lawmakers supporting the bill have made it abundantly clear that they are targeting the Black Lives Matter movement. And here we've got a couple of quotes from lawmakers who have supported and sponsored this bill. So Representative Tim Moore used the word disgusted when he was describing a Black Lives Matter protest that he witnessed. Representative Jay Adams, when he was asked what types of actions he thought deserved heightened penalties, he said pulling down statues is one of his examples. What do we think he was referring to there? Then we've got Representative Tim Moore, who said that he wanted HB 805 to target, quote, those who engage in this antisocial anarchy. Suppose that was also in reference to the Black Lives Matter movement. And then Alan McNeil, in responding to concerns over how harsh the penalties are in this bill, he said, quote, maybe they'll learn their lesson. On the other end of this, we've got Representative Lofton, who we actually just heard from today. And he used the word devastated to describe his son's response to George Floyd's murder. He explained to us that his son wanted to attend a Black Lives Matter protest, but if this bill is passed, he would be afraid to bring them to such a protest. So even our own representatives are afraid to exercise their free speech rights if this bill is passed. Now, our definition of the word riot, as we've already discussed, in combination with the harsh penalties under HB 805, exposes anyone who attends a peaceful protest to potential felony charges. This has the effect of what's called chilling speech, which means that it will prevent a lot of people from exercising their right to peacefully protest. As we just saw, Representative Lofton is one of those people. And as we all know, this is not the first attempt by lawmakers to suppress Black voices. This country has a terrible history of doing just that. And if this bill is passed, it is only going to continue this longstanding pattern. And it's going to send the clear message that our lawmakers don't think that Black lives matter or that Black voices matter. We all need to raise our voices now, and we need to let them know that we're not going to stand for this, and this is not the type of bill or law that we want our lawmakers focusing on. Caitlin's now going to take over, and she's going to talk about the history of voter suppression in the United States and how these harsher punishments are going to lead to even more voter suppression.
Thank you, Amy. And I think you need to stop sharing your screen so I could share the presentation. So we make sure we have the tech.
Let's see if I can figure out how to do that. Here we go.
All right, let me see if I can do this. Should be able to do it by now. Sorry, everyone. Okay. I am Caitlin Kaiser. That's apologize. This is a full screen. I'm trying to get out of it. Sorry, everyone. I have my notes and the full screen is not working. So let me just kick it off. So yeah, as Amy said, I want to speak about HB 805 in our context, thinking about the history and present day. Protesting and the right to assemble and voting go hand in hand. Across our country, the history of protest and the right to assemble has come in many forms for a variety of social and economic injustices, thinking about LGBTQ, Women's March, climate crisis, Occupy movement, Fight for 15, Palestinian solidarity, Black Lives Matter, and the Civil Rights Movement. And looking at the legacy of the Civil Rights Movement of the 1960s, and the Black Panther Party, the focus was on political power. So thinking of political power as the right to vote, economic security, and autonomy, the ability to control one's own movement and leadership. And using protest and voting demands our voices be heard by the government, the state, and oppressive systems and this right is protected by law, as Amy has just spoken about. And as we see today, like then, when there is growing, flourishing political power by Black, Latinx, and other communities that have been historically silenced, there's action by the government to block and or criminalize that speech or action. And thinking, for example, in Elizabeth City, when protesters are protesting against the killing of Andrew Brown Jr. and other Black people at the hands of law enforcement, HB 805 is in line with that legacy of white supremacy attacks against Black people. And so it's important to note this and to really sit with that HB 805 criminalizes our right to protest, assemble, and if it does become law, it will take away our right to vote by imposing a felony sentence. And this becomes a pattern of silencing voices and votes, diminishing political power, and ultimately, stopping the forward change and liberation movement led by communities and Black-led movements. And so I know that we are coming out of time, so I'm going to skip over some items I was going to talk about so I can get to thinking about the barriers to the vote. And this aspect of HB 805 is the felony penalty. As Amy said, that if you are found in violation of this term, this loosely defined term of rioting, you can receive a felony penalty. And this is, again, another act of silence and control. So HB 805 is acting as a gatekeeper to the right to vote and meaningful political power. In North Carolina, when a person with a felony loses their voting rights when incarcerated, and they are restored when a person completes their sentence, including prison, parole, probation, and supervised release. And that is felony disenfranchisement. And on the screen, you'll see that it's North Carolina statute 163-2755. The knowledge and freedom to vote is key to building political power. It also secures, ensures, and preserves all our other civil rights, like the right to protest and the right to assemble. And the disenfranchisement of people with felony records is rooted in inequality. In 1875, in North Carolina, amended its constitution to disenfranchise people with felony records as a backlash to the 14th and 15th Amendments to the US Constitution, with the knowledge that this would disproportionately affect Black voters. And today in North Carolina, Black North Carolinians represent 20% of the state's voting population, yet currently make up approximately 40% of those who are disenfranchised due to the laws that impact voters with felony records. And if HB 805 does become law, this will be another additional penalty for peacefully protesting and acting on our right to assemble. And it's important to note that for returning citizens, voting rights restoration is a challenging and unclear process, and not always the first thought or consider when people are returning back to their communities. And a person may not know or have been provided with the knowledge about their disenfranchisement or reenfranchisement. It creates stigma, and it takes away a person's agency and their own power. Because there is no explicit mandate that the state educate returning citizens about regaining their voting rights, and the state often neglects to inform returning citizens of the necessary steps to restore their voting rights, usually with re-registration. So this is a sort of, this is a withholding of knowledge about voting rights, and it's a system designed to silence voice. And on top of that, once you do have a felony conviction in North Carolina, and you have not completed your full sentence, a person can be prosecuted for voting while they are ineligible, despite not having any intent to defraud the state in North Carolina. And this is called a strict liability offense. So you might believe that you have the right to vote. You might have received wrong information or no information at all, and you go to the ballot box to vote, and you find out that if you do have an outstanding, probation or parole or supervised parole, then you could be charged with, again, a separate felony for illegal voting. And this creates a cycle of voter disenfranchisement. And without an opportunity to protest, thinking about if HB 805 does become law, it exacerbates racial inequality. And I finally just want to note the fact that HB 805 also impacts young people under the age of 18 who do not have the right to vote. HB 805 prosecutes 16 and 17-year-old children as adults with felonies for riding. Young people can drive, they can pay taxes, and for the first time work without any restrictions on hours, and are directly affected by a range of policies concerning education, criminal justice, government spending, and the environment. Yet in North Carolina, the voting age is 18 years old, and therefore many young people use their constitutional right to protest and assemble to speak against or for their rights and dignity. And today, many young people are the front of movements such as the Sunshine Movement, Black Lives Matter, AFL-CIO, and this also goes back thinking about Malcolm X and Ella Baker in the civil rights movement of the 1960s, and John Lewis. And so HB 805 directly impacts young people and who exercise their voice with the threat of felony and the collateral consequences of felony conviction. And I think we are out of time. And I just want to also note the fact that what can we do next? Amelia has already said before we had spoken about all the amazing resources that you can find at nc4bl.black. And it's so important right now to contact your senators. And I think, again, I just wanted to reiterate that our voices and votes are the cornerstone of a vibrant democracy. Protests encourage an informed and engaged public, and engages individuals and communities to share views, express dissent, and expose flaws, racism, and injustices within our government systems. Today we are all here. We were showing up, learning about our rights, and holding the line. And I think an important thing to note about this is as we are doing this work, it's really important to prioritize also self-care within this. And so thank you so much, everyone, for us being in community and in discussion with you today.
Thank you. Thank you so much to Amy and Caitlin with the Southern Coalition for Social Justice, and in breaking down just how this bill impacts young people who haven't even had a chance to begin their life and to have so much of it snuffed out because they chose to get out there and exercise their right to assemble and to protest. Thank you guys so much. That was so informative. It's so important that you understand your legal rights and how this dangerous bill can affect you.